Hello! Today we're talking about the 3 best ways to pass your assets to your children. Hi, I'm Claire Langton Yanowitz, and I'm an attorney at the Yanowitz Law Firm. At the Yanowitz Law Firm, we help families pass their legacies and promote family harmony and reduce taxes. So let's get started. So the first way you can pass assets to your children at your passing is outright. And in outright, your children get their assets in their own individual names. It's really simple, so that's a real beneficial thing to it. However, if you have minor children, you can't pass assets outright to children. That is because when someone's under age 18, if you do that, it will trigger what's called a court-supervised conservatorships. Those can take a huge financial drain on your estate. They're very expensive, time-consumptive, not something that you want to do. So if you have minor children, you need to look into options 2 and 3, trusts at ages and lifetime trusts. And we'll just talk about those in a moment. So if you have adult children who are responsible, outright could be a good option. However, there's no asset protection if someone inherits outright. So that is can be an issue if the beneficiary later on is sued, goes bankrupt, gets divorced. It can be easier for someone to attach to those funds to try and take them away from your child. So that can be a problem with this option. Another thing to bring up to note is your child has the assets in their name and they can spend them however they want, and they can give them to whoever they want at their death. There isn't any control on what happens to those assets. So, they could end up going to an in-law, they could end up being spent very rapidly. And so sometimes these are concerns for parents and sometimes they aren't. So let me talk to you about our second option, which is trusts at ages. So a trust at age means that when you pass away, so second option right here, your assets go into a trust for the benefit of your child. And so if you have multiple children, there usually is a separate trust created for each child. So if you have 3 children, there's basically 3 buckets created at your death, okay? And these trusts can be created under a will or a revocable trust, okay? So your children can inherit in trust irrespective of if you have a will or a revocable trust. So that's something to keep in mind. Now, with trusts at ages, the trust terminates at a certain age. So it passes outright when the child is older. And so the idea is that when the child is young, someone else is in charge of the money, is investing it on the child's behalf. And then when the child is older, the trust terminates and the child inherits outright. So this can work out really well for minor children, for children who are maybe young adults and their parents feel that they need some more help with investing, and maybe they wouldn't make good financial decisions if they were given a bunch of money all at once. Even though legally you can inherit outright when you're age 18, I find that most parents, don't want their 18-year-olds to come into a big chunk of money. So oftentimes people will want their children to inherit in trust, oftentimes until their mid-30s, but sometimes we'll have a trust terminate in the 20s. So that's something that you have to think about if you pick this second option, is when should the trust terminate? So when's the final time? And when the trust terminates, there isn't any asset protection. So if the kid is sued, goes bankrupt, gets divorced, the trust no longer has the ability to kind of protect that person who's trying to take away the assets. So you lose the asset protection when the trust terminates. Now, before it reaches the termination age, the trustee can spend assets for the child's benefit. So sometimes I hear from people, I don't want to lock away these funds, so my kid can't get it till they're 35. I want, these funds to be able to use to pay for my child's school and maybe buy their first home, things like that. So to clear up that misunderstanding, absolutely, the trustee can spend the assets, or even when the child is older, give the child an allowance to live off of. So the trustee can help. It's just when the trust terminates, now the child is entirely in charge of their money. Now, prior to termination, we usually set up these trusts so it terminates over different time periods. So, for example, maybe when the child hits 25, they get a third of it outright. So at 25, essentially the trustee transfers them a third of the money and they can do whatever they want with it. The trustee has no duty to investigate. They can blow it. They can make good decisions with it, whatever. But they get a chunk of it outright at 25. Then maybe they get another chunk at 30. And then finally the trust entirely terminates at 35. So the benefit of that is it's kind of not all or nothing. The child, you don't know when your child is going to become mature when they're older. There's plenty of 25-year-olds who are mature, but sometimes it takes longer with different people. And sometimes I meet with people and, they have a 4-year-old and a 6-year-old. Who knows when those kids are going to be mature? We can only guess. So what we do is we give the children a bit of free rein as they get older, but we don't give them all of their inheritance without supervision. So that's why we call it trust at ages, because at different ages, the trusts terminate. Now, the third best way to pass your assets to your children are in a lifetime trust. So now I'm moving on to this third option. And the people that pick this third option are the sort of people that are concerned about asset protection. They really want to prevent their child, from someone trying to take the money away from their child. Maybe they feel like their kid is in a bad marriage and they're afraid if that ends, they might have their inheritance drained, or maybe the amount of money that the child inheriting is very significant. So, for example, maybe a child's inheriting $3, $4, $5 million. And, it's a big sum of money and they don't want anybody to be able to kind of attach to that. So they want to provide as much protection as possible. So people who are giving larger sums to their children, people that are concerned about asset protection, both pick this option. Now, a third type of client that I see pick this option is a client who has a child who is struggling. So maybe they're struggling with chemical dependency. Maybe they're struggling, they're in bankruptcy. They have all sorts of creditor problems. Maybe not struggling, but they're disabled and, they really can't inherit in a fashion where they can control the money during their lifetime. In that instance, inheriting in a lifetime trust can be very beneficial. And something to know with this third option is you can draft many different flavors of these lifetime trusts. You can draft them. I've drafted them for very responsible children who, the sole reason is we want to provide asset protection. They're inheriting lots of money. We want to prevent others from taking it away from them. And so asset protection is the primary goal. And so we provide very liberal distributions. I've also drafted these types of trusts for children who maybe they if you gave them $1 or any amount of money, they're going to spend it immediately. And so maybe for those types of children, we draft it in a flavor where they only have conservative distributions because we want to preserve the assets throughout the child's lifetime. We don't want them to spend it all immediately after death. So something to know is these different types of trusts, these lifetime trusts, can be drafted in many, many different ways. Another benefit some parents find with these lifetime trusts is you can not only control how the assets are spent, you can have different standards on, if they're from liberal to conservative on how the money comes out, but you can also control how the assets pass when the child dies. So for example, if you want the assets at that point to go to their children, you'd prefer it not to go to a daughter or son-in-law, the trust can say that. So you can put into these types of trusts where it's going to pass at death. So this third prong right here, this is something optional that you can put in or not, and some clients view that as a benefit, so I bring that up. Well, thank you so much for watching my video.